You're listening to the Valley Current.
Hey, Bob, how you doing? Got a gray hair. How do you stay so youthful? All right, I can hear you now. So that's okay.
Good. We're doing good.
That's okay. It's a little bit like a preview of what was going on where Sam Bankman-Fried, also known as SBF, really was probably mostly not hearing the advice of his lawyers or the advice of probably a million other people. And he was like not really communicating because he's so used to being in the video game world.
I think the parallel you were trying to draw with Donald Trump is true in this respect. They both had incredibly indulgent, you're a king, you're a god parents, and they grew up acting accordingly, and you can see it.
Yeah, that's a really interesting observation, because this whole question of how is character formed and how are ethics transmitted in society's evolution, these cases, a lot of them, you could go back probably for decades and look at the history of high profile cases. I mean, there's been a number of them since, the last 5 years, including the one involving Theranos and Elizabeth Holmes, where great wealth is achieved, but at the cost of a huge breach of ethics. And just to set the stage for a second, because many people may not realize it, there's been a big criminal case going on in New York City in the federal courts, while there's a big civil fraud case, a big criminal fraud case against Sam Bankman-Fried, SBF, in New York's federal court before Judge Kaplan. There's also a parallel, but in state court, civil, not criminal, fraud trial, tax fraud trial against the Trump family. Some people call it the Trump crime family. The Trump family, Donald Trump Sr. and Jr., as well as a bunch of other family members. I think Ivanka is trying to get out of the case, or maybe she has gotten out of the case and she's trying to get out of testifying. But before a state court, New York state court judge, Judge Erganwan or something, I'm mispronouncing it, I'm sure.
Something like that, yeah.
And anyway, those two cases are taking up a lot of bandwidth of reporters and I'm sure hotel rooms and restaurants in that lower part of Manhattan that we both know because we both lived there and to some degree went to at least high schools there. I think you went to college in Boston, right, Bob?
Waltham, yes.
Right. And then I went to college in Brooklyn, City University of New York, Brooklyn College, and then in the Graduate Center in City University of New York in Manhattan. So we're both very familiar with Manhattan and that area and those courthouses. And it's an interesting time to see these two cases. And of course, yesterday, very quickly, less than 4 hours after nearly 4 weeks of trial, we have a verdict on 7 counts, all of guilt against Sam Bankman-Fried, which I think we sort of predicted, but we thought it might take longer. I guess that's my summary of what we were talking about for the last few days, right?
Well, you and I were at a firm, Fenwick and West, and there was a litigation partner there named Charles Craycroft. And Craycroft, at this time, I was like a second-year associate, said, right, there's no such thing as certainty. I don't care what the case is. It will never be better than 80%, never. And I thought, well, that may generally be true, but maybe this is an exception. If you had offered me 4-1 to bet against the conviction, I would not have taken it.
Right.
And so you and I began a discussion about what made this case so slam dunky.
Right.
And unfortunately, we scheduled this session for Friday morning Eastern time in the belief that no jury could get through 7 counts and 6 elements of each count in 4 hours, but we were wrong.
We were both
okay. That was not 80%.
Right.
But so unfortunately, this is like wisdom after the event. But here we are.
Right. I mean, I think it's a good thing for criminal defendants and probably even civil defendants to learn from, which is, look, juries make decisions based more on what I call emotional reasoning than they do based on cold-hearted, logical reasoning. They made a judgment call that he was guilty. They might have even made it as early as hearing the opening three witnesses of the prosecution.
Well, that is just possible.
Right? The C-suite people, Ellison, who was a girlfriend as well for a while, Wang and Nishad Shah. I mean, these were three people who both pled guilty and said that they admitted guilt beyond a reasonable doubt of the same charges or similar subset of charges. And they're going to get much, much lighter sentences as a result of cooperating. And once you hear that your three consigliere that are around you are all saying we conspired together to basically defraud customers and investors, and you have the customers and investors that have all lost their money, and there's $8 billion that was the size of the loss, you really get pretty much convinced that what is this guy going to say? That he was just deaf, dumb, and blind? He's a pretty smart guy. He's an MIT graduate.
Well, he tried that, didn't he? You know, sorry, I fucked up. I mean, it was basically his defense.
Right.
And the fucked up defense is fucked up. It just doesn't fly.
It doesn't
fly. If you
fly.
take on those responsibilities, you have them. Sorry.
Right. It doesn't fly, particularly then had a couple of other witnesses that weren't co-defendants, including a lawyer, because there is something called the crime fraud exception to the attorney-client privilege. And this was clearly a crime. And there was a fraud. They had both elements of it, even though you only need one. And the crime fraud exception allowed this guy who was actually also a former Fenwick and West. We didn't know him because we both left there many decades ago, but he was a former Fenwick and West, because Fenwick and West were the attorneys for FTX, or at least one set of attorneys. And basically he said, this guy came to him and said, let's go for a walk on the beach, because they were then located in Bermuda. The company actually started in Hong Kong and moved to Bermuda. And they basically walked around and SBF asked him, is there some, defense that we can assert to why we used $8 billion of customer money that was supposed to be in segregated accounts, essentially like a trust fund violation? And he said, they're not plausible. There are defenses, but they don't meet the facts here. The facts don't match what the law would require for such a defense. I mean, that was like icing on the cake. He was basically asking, can you help me construct it, or potentially asking, can you help me construct a cover-up as to why we did it and why it was legally okay? And I think the jury that was it. I mean, I think that you don't get any better admission than that, right? I mean, if you think about it.
I think there were several elements, and this case is unusual in that all the elements aligned. I mean, so you may have the preponderance of weight on one side, but there will be a few chinks on the other side. And if a jury is so inclined, they can go with the chinks on the other side. In this case, everything was aligned against the guy. I want to go back a year ago. His companies collapsed. There was a run-on of investors. They couldn't be paid. He went into bankruptcy. And then what did he do? Charges looming, obviously. You don't disappear $8 billion and go, sorry. No. In that context, he began giving media interviews, apparently dozens of hours worth. He began releasing writings, hundreds of pages of writings. And all those things are called party admissions. When you're a party to a lawsuit and you make these statements out of court, they can all come in without question.
Right.
And I asked you, Jack, in the course of this, whether you ever had a client who did that, who just kept making party admissions with litigation, let alone criminal. If it ever had happened to me, I don't know what I would do. I would break all his fingers, I guess, so he couldn't tweet anymore. What would you do? It's unheard of.
I can tell you the one case I had that was sort of reminds me of your question. It was not a criminal case. It was a civil case. And in general, the client kept talking, including in his deposition. And this was like 25 plus years ago when it was clearly illegal to smoke marijuana. He would say, like, I regularly smoke marijuana. I'm proud of the fact that I smoke marijuana. I think it enhances my creativity. I won't mention the case. I won't mention who was in it. But I kept kicking him under the table. Like, you don't have to volunteer that you're doing something illegal. Of course, the other side just went to town with those admissions to say this guy basically is a criminal. And of course, marijuana at the time was illegal, but he was proud of it and he thought he was very avant-garde. And I just didn't know how to control him, and he was to some degree uncontrollable. And I think it is the lawyers, particularly a lawyer that's doing trial work, most worst nightmare. And in this case, it's really stunning because I think he had a good set of lawyers. I'm sure that they did their best. And at the same time, everything this guy did had consequences that were disastrous, including defying Judge Kaplan's order that he shouldn't be tweeting and doing a bunch of stuff because it could affect the jury or the potential jury at the time. And he just ignored it, which is another parallel with Trump in a lot of ways. But Trump, of course, is running for president and he thinks he has enhanced First Amendment rights and he wants to presumably challenge any gag order, which I assume he's doing. I think pretty much he's doing. But net, this guy put himself in jail. He had home confinement with a monitor with an ankle bracelet on in Palo Alto in a luxurious home that his parents have on the Stanford campus where they both teach as law professors, which is really another stunning aspect to this case, which is the parents are both law professors at Stanford. And I got to believe that they're just going through a hellacious time right now. If you think about it, this isn't their only child, but clearly the most successful financially and probably now the worst disaster that a parent can imagine other than a child committing suicide, I suppose. I guess that's comparative to some degree. But you had some comments about the parents that you thought at the beginning that maybe to some degree play out here, right?
This is one of the situations where you just take an instant dislike to somebody, and I did, okay? And everything that comes out of my mouth about the parents will be radically biased, and so let that go. I do want to say that the pages and pages and hours of party admissions, almost unheard of, is only one element. That enough would probably be enough to bury the average defendant. But there's more, okay? Yeah. There's the second element is what you said. I mean, the entire inner circle turned on him and in chorus pointed out that everything was his fault. And since he was the CEO and the founder, that's not totally unbelievable.
Yeah, you have it.
I mean, it was just a unanimity of chorused testimony against him. And then comes element 3, which is his rebuttal or his direct, followed by cross-examination. His direct was what it was. Yes, it was very talky. It was very, I'm really smart. I knew what I was doing, blah, blah, blah. But so I said the first element were all the admissions. The second element was the very strong direct case the prosecution put on. And I would add that those 3 witnesses were basically undinged by the defense cross-examination. So you had unrebutted, unanimous testimony, which is rather stronger than is usually the case. But that's only the second element. Then comes the third element. The third element is his own direct, followed by cross-examination. He was faced by an incredibly able prosecutor named Danielle Sassoon, who I'm sure has a bright future, who had all of his admissions in her back pocket. So whenever he said anything in response to her, she said, but what about, and contradicted him. it was like it was a real pummeling. And not only that, he then retreated into a sort of pathetic evasiveness. No, I don't really exactly recall those precise words. Well, look, the question is not whether you're not going to be guilty of perjury by saying you don't recall the exact words. The question is what effect you're having on the jury, and the effect of mere evasiveness on the jury when the prosecutor has you all lined up in front of her is devastating.
Right.
And yet there's more. And then the fourth element is he's not very likable, frankly. So if you want to talk about the emotional logic of it, that was against him. So as I say, it was like a perfect alignment of a terrible defendant and a terrible defense case.
Right. In the Elizabeth Holmes case and the Sunny Balwani case, two separate cases, both convictions in the court in San Jose, California, federal court, also criminal fraud trials against them. The jurors used kind of a 5-star system to say whether a witness was or was not credible, with 5 stars being the highest and I guess 0 stars being the worst. And according to the reports, most jurors viewed Elizabeth Holmes as best 2 stars. I guess we would say that probably SBF, if that same system were used, would be like 0 stars in terms of his credibility. But these other witnesses, the 3 C-suite executives that all pled guilty, I think they all came across very credible. And not that they had just cut deals, but they basically were repenting that what they did at his instruction was a huge, huge criminal error, thinking that they could get away with it. Now, I'll make a footnote point. I think that if they had remained in Hong Kong under the Hong Kong laws and the lawyers had written into the agreements that the money can be loaned and reloaned, including to affiliated parties, because that was really his defense, that he thought the money could be loaned, at least from a pool of money where other people were borrowing, like the margin pool. Like there's a class of customers that are purely cash customers. They have no margin, no borrowing ability. And then there's a class of customers that have margin ability, the ability to borrow. And basically those customers in that pool, they're all borrowing from each other is the theory. So why can't Alameda Research borrow from FTX in a similar way? They're a customer. Now, of course, they had super borrowing capacity well beyond all the customers. So there's a form of discrimination. You'd have to disclose that too. But I think if all that stuff were in the agreement, which by the way is a shrink wrap type agreement, it's just electronically signed. It's not an ink signed agreement, but electronic signatures work. Had they done all that and stayed in Hong Kong and been governed purely by Hong Kong law, it might have worked. I mean, I think there's an extradition treaty. I don't know for sure because China has now taken over Hong Kong, and that may have changed things from when things were under the control of the British. I haven't double checked that, but it might have actually enabled what they did to be legitimate. But once they moved to Bermuda, and presumably it was viewed like a different body of law in the case of any US-based investor, because most of the other, I think all of the other foreign investors were supposed to be foreign. All the other investors or all the other users were supposed to be foreigners. And indeed, the first witness they put on was a Brit who was a trader and who lived and worked in England, I think in London, and was some sort of commodities trader. And he lost $100,000. Like, okay, but where's the U.S. citizen that actually lost any money? Because in general, the securities laws and the commodities laws are supposed to apply just to U.S. based victims, not overseas. The overseas laws are supposed to protect them in theory. But, that's not the way this played out. And I could be wrong on the reach of these laws, but that's generally been the historical view of how the laws have worked. So I don't know, that whole set of arguments that I just made couldn't be made and weren't made, but he did make the margin argument, and that just probably completely got blown away by the agreement says that the money is being segregated into separate accounts that are your accounts. So it's your money in your account. It's not being touched. It can't be lost. Like, they basically gave a lot of assurance. And that's what the lawyer who wrote the agreement, who ended up under a non-prosecution agreement, this Fenwick and West former lawyer, then became the in-house general counsel at FTX, said that's the way it was supposed to work. But he didn't know that it wasn't working that way, because this was all done inside the code, which is not obviously transparent at all. So it was a pretty novel situation for anyone to monitor. And just saying, as you say, that SBF said we should have had a chief risk officer because that would have been like my control person. Who knows whether he would have followed the advice of a chief risk officer, or anyone for that matter. Because obviously he was not disclosing things to his own lawyer, who would have had to tell him what he was doing illegal. And if he didn't change, would have had to resign. So obviously, there's a whole set of facts there that came out based on this crime fraud exception to the attorney-client privilege that really iced the cake. And the cake was pretty iced already before any of that really occurred. So it's really a unique story and a sad story, and one that's going to go in the books. I don't know that I see any huge appellate errors in terms of what Kaplan did. Judge Kaplan did. He's a 78-year-old jurist. I don't even think he takes senior status, which he could. So he takes a full caseload. He loves working, apparently. He gets a lot of high-profile cases. This is one that really will go down in the books for him. So an interesting story for him, an interesting story for Danielle Sassoon, as you say, an interesting story for the other prosecutors on the team, including the guy who gave the closing argument. And I'm sure an interesting story for those defense.
Are you inclined to criticize the defense counsel, either on the grounds of poor cross-examination of the prosecution witnesses, or on the ground of very poor witness prep for Sam's testimony?
Well, I am not one to criticize lawyers that are in the heat of battle, and I think he was stymied by, number one, his client was not as available to him, because once you're in incarceration, you have to be visited at the jailhouse, which means you got to get from New York to Brooklyn. Not that that's a big deal, but in traffic, you're probably going to kill an hour just getting into the facility. You got to go through security. You got all the rules and regulations on what you can bring in, what you can't bring in. It's not like being in a law office with a lot of support and copy machines and a ton of people helping, where your client's in a conference room with a whiteboard and you can really go over what it is that needs to be done to put on the best case. That was strike one, which of course traces to the violation of the court's order that said, hey, you're not to tweet anymore. Strike two is, I don't think he's capable. I had the advantage of reading two books going into watching this case that were both published more or less ahead of the actual trial. One was by Michael Lewis called Infinite. It's a great read, but it's very apologetic to SBF. And a lot of people criticized it for that reason. And then there's a second one by, I want to say, a Bloomberg reporter, and I forget his name. It hasn't gotten as much press, but it's much more critical and in many ways much more factual. And the guy had written a Bloomberg article a while ago. And this is more like in the style of the guy that wrote the critical book about Theranos. It's really an investigative report about what went on at FTX. And I just can't remember the title of it. It wasn't as memorable as Infinite. I'm sure the latter book has not done as well as the Michael Lewis book, but both books really tell the story from, one angle versus another angle. And when you listen to them together, as I did, as I exercise, I listen to stuff, you get this big picture of a guy that thinks that he is beyond genius. And he's aiming to be this first trillionaire, maybe even ahead of Elon Musk. He was aiming for something that he claimed was a better purpose to the money, which is this idea of effective altruism, which was a term that I had heard many years ago. I think there was a guy at Yale named Peter Singer who came up with this idea that, well, if we had really rich people do really smart things with money, they could actually change the world. So if Musk and Bezos and Gates and Buffett, and you can go down the list of, the 100 billionaires that the US has printed money for or generated wealth for, pooled together their resources and attacked hunger, attacked viruses, attacked nuclear weapons with some new thought leadership and change, we wouldn't have things like the Gaza Strip situation or the Ukrainian situation. I think that's sort of wishful thinking, or COVID-19 or Iranian nuclear risk or any of the list of existential items that could wipe out the planet. And I don't know that I believe that, but he claims...
You think the bloom is a little off the rose at this point?
Yeah, I mean, I think effective altruism is shaking in their boots that it's just a front for fraudsters, and it's not really a real charitable mission. Like, there is no, to my way of thinking, and I could be wrong on this, there's no Red Cross kind of version of effective altruists in some sort of band of angels that are somehow going to put together mission-driven initiatives.
No, that's exactly right. You can trust us because we're wonderful, wonderful people. And right. As soon as I hear the wonderful, wonderful people thing, I reach for my hat, my coat, because come on.
Yeah, you could say it's easier to raise money.
There's no qualification except their own self-assignment.
Right, you could say it's easier to raise money if you say it's really for this noble purpose. It's like a Robin Hood kind of purpose. There actually is a company called Robin Hood that has successfully done that as a way to kind of create a mission-driven trading platform for kind of reducing transaction costs. That's called Robin Hood. Not that it's in this whole situation. It's just interesting how these ideas proliferate. But yeah, it's an interesting question about how he used that to also garner talent, which is he wanted talent that wasn't as much into the money as they were into the mission. And I think the three co-defendants, the people that pled guilty, sort of said, we really had this beautiful idea of taking money, and they did give some charitable gifts. They didn't give as huge a number as the numbers that they spent on advertising, because they gave huge amounts of money to like a football player and his wife and actors. I mean, there's so many, football commercials.
Yes, effective altruism predicate is we're wonderful, wonderful people. I mean, there's no underlying idea. There's no underlying organization. It's just them as individuals telling us how great they are. Why would I believe that?
Right. Oh. Let's wrap up with this idea, which is there actually are 3 books. I actually now found the author of the second one. Michael Lewis is the first one. His title is Going Infinite. The guy from either Bloomberg or Newsweek, or he's more of a reporter than he is more of a journalist than he is a writer. Michael Lewis is, but the book is good. Is by Zale Faux, F-A-U-X. It's called Number Go Up. And maybe that's a weird. He was actually first. His book came out ahead of Michael Lewis, and then now a third book, which I haven't read yet, by Brady Dale, that's called SBF, how the bankruptcy actually is what got all the evidence out. Because once SBF signed the bankruptcy papers in Bermuda, that essentially changed control of the company to a bankruptcy trustee. Had he actually not signed those papers, which I think he controlled the board of directors. I'm not even sure he had a board of directors. Maybe it was just him with these three people who all testified against him. But had he decided, look, I'm going to try to get that money, because I'll wrap up with this one point, and the judge didn't allow this evidence in, and there was a big hearing about it. He made a bunch of venture capital investments with a lot of this money, or some fungible use of this money. And one of them is actually apparently going to turn out to be worth a lot of money. I'm not sure it's going to add to 8 billion, but this company Anthropic, which is an AI company, has gotten a big valuation from Google. And he got in early with a $500,000 investment of FTX funds. And that could be worth $5 billion with a B. So in theory, in theory, I'm not saying what he did was legal. I'm not saying no harm, no foul. I'm not saying that maybe the law wouldn't have caught up on him. But had he kept control and retained control of all the records, and maybe retained control of the lawyers and a bunch of other stuff, it would have taken a masterful way to get out of this nosedive, and found a white knight who was ready to back him, like an Elon Musk or a Bezos or a Gates or Buffett or some sort of billionaire. I mean, Buffett almost bailed out long-term capital many decades ago. It's a different story for a different time. But had he found someone that said, yeah, I'll give you a check for $8 billion and you could refund all the customers, but I get control of basically Anthropic and a bunch of other investments you've made, and I'm going to own, 51% and put a board in and try to salvage the FTX name, but you'll be a minority player and you'll have a job, and I'll make sure the lawyers who need to defend you are paid and give you indemnification, all that jazz. I mean, I'm giving you a broad-based outline of what maybe could have saved him. He tried to get Binance, who was an arch competitor, to save him, and they completely threw him under the bus. But had he got somebody that saw the value of these venture capital investments he made and felt comfortable cutting a check for $8 billion, maybe it needs to be even more, the customers would have been refunded. And then there would have been an argument like, we paid back the money. So maybe for a temporary period of time, the money was juggled around, but we were okay and we covered it. And the money's back in the accounts, or the money's been, there's no complaint. There's no first witness who says I've lost money. There's no witness at all that says they've lost money. Everyone's been made whole. Everyone's been paid back. I mean, I'm not saying that works, because a violation is a violation and misrepresentation is a misrepresentation, but it's a much harder case when there's no spilled blood. There's no bloody.
It's a much less sympathetic case for the prosecution, right, when there's no raggedy widow who lost all her money, of course.
Right.
His real problem was he couldn't play inside the lines.
Right.
Regulators are stupid and rules are pointless. And as for those bail conditions, who cares? I mean, he just thought he could run the whole world on his own terms, and he was wrong. That's all.
Right. And I have to say, there'll probably be a lot more books, certainly a movie. I'm sure Michael Lewis is already working on that. Michael Lewis comes out of this kind of making a lot of money. I don't know if he's going to give it to effective altruism. I doubt it, but who knows? Maybe there will be some good that comes out of this. There's a lot of other authors, including the other two that I mentioned. There'll probably be another list of books. There'll be probably a great movie. And in the meantime, you've got a shattered family, for sure. You've got a lot of people that haven't been paid back. There's a bankruptcy going on that's trying to collect money and clawing back various money from various other people who were able to get out earlier, and then doing some sort of equitable distribution of it. Maybe this Anthropic investment will be liquidated and folks will be made whole. It'll be weird.
Do you think his parents are on the hook?
No, I tend to think that they were probably too far removed, although I think the father was a consultant as a tax person giving tax advice, because he's a professor of tax law at Stanford. But I don't know that to be a fact. I think they are big supporters of this effective altruism movement, and they saw the mission as great. There is a civil case pending against the parents that's seeking to claw back some monies that they supposedly shouldn't have received through him. I don't know what the status of that case is. There is a case, even as a class action case, even against Fenwick and West, claiming that they should have somehow policed this. I think that case will probably be dismissed, but who knows? I mean, that's being defended by another law firm. I've just generally followed all this because, look, in any story like this where billions of dollars are lost, there's always a list of defendants that get sued on the theory that they somehow should have done something to stop the train from leaving the station or slow it down before it went off the tracks. I mean, it's inevitable. So it's an interesting whirlwind of civil cases that have followed this criminal case. And here's the punchline. There's a second criminal case that's scheduled for March involving the fact that there's an admitted bribe to some Chinese officials over crypto that was frozen in China. And apparently they tried to get it unfrozen by bribing some Chinese officials, and they more or less have admitted that. And he's admitted it.
That hardly seems fair. I mean, everybody bribes Chinese officials. Come on.
But there's a federal act.
My understanding, by the way, is that Judge Kaplan has asked the prosecutor's office whether they now intend to proceed with
Yeah, I think he's more or less.
Case.
I think
and they may say no because really, what's the point?
Yeah, I think he's saying to them, you've already nuked this guy. You don't need to kind of bury him. And it's not really going to affect my sentencing. My sentencing is going to be my sentencing. And if I sentence, it's probably going to be concurrent. But it would presumably back them up if there was a reversal on appeal. This federal law that's been around for quite a while, which is the Foreign Corrupt Practices Act, it's pretty strict.
The first case I ever had involved, it was in the days of, I was at Arnold and Porter. That was in the days of the Shah. And the Shah's brother-in-law was the air minister. And Bell Helicopter, as I remember, had to pay him a large amount of money to rent air in Iran to fly the helicopters in. And then they tried to ding them. Right. I mean, how unfair is that?
Well, that's the law. I mean, that's the law. And it seems to me that the judge is sort of signaling, I think, the way he set his schedule, because he set sentencing for March 28th. So mark your calendar for March 29th, because we should do a follow-up show about what kind of sentence. My prediction is it's going to be at least 30 years, probably more. Ellison and Wang and Shaw, my guess is they'll get 3 to 5 years each, maybe even lighter than that, because they fully cooperated.
Yeah, I would say exactly so.
But I think he's facing probably through his 60s. He's 31 right now. I mean, that's the other last observation is all the various players were fairly young. And he was a very young billionaire. I think he might have been the first billionaire to ever get there by age 30 in the United States. Bezos wasn't there by age 30. Musk wasn't there by age 30. I don't think Gates.
What about Zuck?
I don't think Zuckerberg was there by age 30 either, but I could be wrong about that. I don't know. I mean, we can check that data, but he was one of the youngest, certainly the fastest, because this whole thing starts in 2019 and he's a billionaire by 2021, at least on paper. And everything unravels starting in 2022, and the whole criminal thing gets started in 2022 and gets tried in 2023, where we are today, in roughly less than a year. And I followed the PACER filings, the online filings. It's like 400 docket entries. It's been a very heavily litigated case in many ways because the early incarceration resulted in a lot of attempts, including in the Second Circuit Court of Appeal, to try to get him out of the incarceration for violating the court's order. And, there was a lot of activity over that issue. But just generally speaking, it's quite a story, and one that happened very, very quickly, and one that had this parallel production of books and audios and probably soon films and many videos on YouTube. So we're going to see some really interesting stuff play out at sentencing. and some interesting decisions that'll get made about this second case, which I don't think they're going to offer him a plea deal. I think they want to get a very public sentence out of this. I think he is being really skewered in a legitimate way.
I agree with that.
To make a statement, to make the kind of statement that they made with respect to Theranos. And ultimately, I don't see Judge Kaplan.
More so, Theranos was just herself, but this is the entire crypto industry, if that's the right word for it.
Right.
And they don't like this Wild West stuff. They want to get it under control.
Right. And interestingly, Bitcoin and Ethereum and other major cryptocurrencies have done better during the trial. Now they've, I think, retraced some of that movement as a result of the conviction. But, who knows? The industry continues to grow even in the face of all this. Maybe the common person has become far more educated about the risks of this kind of speculative trading, because it is quite speculative. And, I've had situations where clients have called saying, I've lost a bunch of money. Can I do anything about it? And I've often said, look at the paperwork you signed. It very likely makes 100% clear that you're at risk, just like you are with any other speculative investment. And there are no guarantees. I mean, banks go under and deposits even get lost, and deposit insurance has its limits, its dollar limits, which is why people often create separate bank accounts with separate amounts of funds in each to make sure they can get that federal depositor insurance up to whatever the limit is these days, which I think is like $250,000. So there are people who have $1 million in banks. They're in 4 separate accounts. Often it's 4 separate banks for that very reason. So there's a lot of learning in all this, and we'll keep our eye on it and come back certainly before or at the time of sentencing, because I'm sure there'll be some really interesting developments between now and then.
Good. Looking forward to it.
Thanks for your time, Bob. I really appreciate it. I appreciate you coming on quickly to do this. And obviously we're doing it in real time. So it makes a difference, because there's a lot of interesting intersections with our lives and Fenwick and West. And hopefully the firm's reputation won't be injured by this. They're a great firm, and we certainly learned a lot, each of us there.
Well, as Carmen said, anybody can hope, Jack.
Exactly. Take care, Bob. Talk to you later. Bye-bye.
Okay, see ya.
Tune in next time on The Valley Current.